Yes, Mr. Buck.
Morning, my lord. My lord, I appear for the appellant in this matter, my learned friend Mr. Cohen for the respondent. My lords, the claimant's appeal is brought against the decision of Upper Tribunal Judge Ward, dated that appeal being the 4th of June of last year, 2025. Leave for this appeal being granted on the 30th of July by Lord Justice Arnold. And my lords, if I may just deal with some documentary issues prior to commencing, just to attempt to ensure that we all have what we ought to have. There is a core bundle, my lord, of some 147 pages. Supplemental bundle, I believe, of 82 pages. An authorities bundle of 285 pages, and 2 skeleton arguments. Now, in terms of the skeleton arguments, my lord, they ought to be, or at least the appellant's skeleton argument ought to be in the core bundle in any event, if that is not the
Right. I find them both in my electronic bundle, at least.
My lord, as long as we all have what we ought to have.
Yes.
And my lords, this appeal is brought on 3 grounds, all of which relate to the originally impugned decision of the respondent not to review the appellant as a prisoner, not to review the appellant's Category A status by way of oral hearing. The originally impugned decision can be found within the core bundle at pages M145 to M147. Original statement of facts and grounds, L129 to L144 of that same core bundle. And the decision under appeal, my lords, at G40 to G50. And there are 3 grounds of appeal as noted, my lord, and perhaps I can summarise them as follows. Firstly, that Upper Tribunal Judge Ward departed from the relevant test and guidance per the Prison Service Instruction 8/2013, and of particular relevance within that, paragraph 4.7 of that Prison Service Instruction, and we can see that at B258 of the authorities bundle. Essentially the question of important facts in dispute. Second ground, my lords, that there was a failure to consider that a dispute between the local area panel, the LAP, on the one hand, and the defendant on the other, can of itself constitute a relevant dispute for the purposes of the test and guidance contained within that PSI. And I refer specifically to the case of Crown on the application of H. And I will deal with that in a little more detail subsequently, my lords, but we are considering paragraph 23 of that case, which is at A60 of the authorities bundle. Third and final ground, my lords, that Upper Tribunal Judge Ward erred in concluding that it could rely on the defendant's position in respect of reports that were seemingly missing from the bundle of documents that led to the originally impugned decision, without that position being confirmed by accompanying evidence, for example, a signed witness statement. So those are the 3 grounds upon which leave has been granted and to be argued this morning. My submissions are in 3 parts, my lords. First, very briefly dealing with the factual outline. Secondly, again, briefly dealing with the law. And then the third and final part, the substantive arguments themselves. And in dealing with the factual outline, my lords, the same is found within part 3 of the original skeleton that was filed before the administrative court, pages I68 to I70 of the core bundle, and again within the skeleton argument for the purposes of this appeal, paragraphs 4 to 17 of that skeleton argument. My lords, I don't simply intend to read that out to the court. It is there in writing. But perhaps if I can try and provide a little context to the submissions that are to be made and deal specifically with elements of the impugned decision from Upper Tribunal Judge Ward, where the appellant says the issues arise. And effectively, my lord, what the appellant says is that we are looking at 4 paragraphs of that judgment where we see the issues. Firstly, paragraph 47 of that judgment. And where it reads as follows.
Give us a list of the 4 paragraphs so that we've got them in one place, and then we'll go one by one.
We'll deal with paragraph 47 of the judgment.
Yep.
Paragraph 53. Paragraph 55. And paragraph 56.
Thank you.
And in rating those 4 paragraphs, I don't seek to say that the remainder of the judgment is irrelevant. It's just that those are the important points from the appellant's perspective for the purposes of context. So 47 first reads, there was no dispute of fact about the claimant offending, the various interventions he had experienced, his disciplinary record in prison, nor, as far as I am aware, any other potentially relevant primary fact. 53, the judgment reads, I was not offered any evidence concerning... And my apologies.
Just pausing. So 47 you link with ground 1.
With ground 1, my lord, yes.
Yes, 53.
Paragraph 53 I link with ground 3. Paragraph 53 reading, I was not offered any evidence concerning Miss Mitchinson's 2 earlier reports, but Mr. Cohen's submission was made on instruction from the defendant's officials, and I am prepared to assume, in the absence of any reason to consider otherwise, that they will have been aware of and complied with their duty of candour in responding to the request for a written submission. Odd though it may be thought to be that the earlier reports do not figure in the Category A dossier, I do therefore accept that they were before the Director. Paragraph 55. Paragraph 55 relates arguably to grounds 2 and 3, and to a certain extent ground 1 as well. Paragraph 55 reads, from what she wrote in her updating report, Miss Mitchinson's earlier report reflected the same position and will have been considered at an earlier Cat A review. That does not mean that they were necessarily irrelevant this time round, but their weight as an indicator of the necessity for an oral hearing will have tended to reduce as a result. I have therefore concluded, for the various reasons in this paragraph, that the existence of the 2 earlier reports, specifically referred to in Miss Mitchinson's updating report, does not materially add to the case for an oral hearing. The 4th and final paragraph, my lord, paragraph 56, this again relates primarily to ground 2, but to a certain degree ground 1 as well. And paragraph 56 reads, the Director might not have followed the professional's reports in relation to the decision he alone was tasked with undertaking. There is no indication that the impact of the reports, whether in light of the previous paragraph Miss Mitchinson's or anyone else's, was susceptible of acquiring materially added weight as the result of an oral hearing. I agree with Mr. Cohen that a requirement to demonstrate a longer period of good behaviour does not mean that a person is at an impasse. The very existence of the requirement demonstrates how an impasse can be avoided. My lord, moving through to the statutory and policy framework at this stage, and again I can deal with this relatively quickly, or at least I hope to. Paragraphs 19 to 24 of my skeleton argument, but to deal orally with some short points. The relevant test to downgrade a Category A prisoner to conditions of lower security. In order to do that, there must be convincing evidence that the prisoner's risk of reoffending, if unlawfully at large, has significantly reduced, such as evidence that shows the prisoner has significantly changed their attitudes towards their offending, or has developed skills to help prevent similar offending.
Could I just ask you, while we're focused on that formula, that is the test which you say the Director must apply?
Yes, ma'am.
Is it the test that the LAP applies?
My Lord, I think in that context, it's not necessarily a test for the lab. If we look at the position and the mandate of the lab, it's to consider the position and make a recommendation as far as it is concerned. It is the director that makes the decision, as it were. So the lab will consider, or at least it should consider, that same test in making its recommendation. But I think to be entirely accurate, the test is for the director rather than the lab, although it will feed in.
Well, the focus in my mind was at the words "at large."
Yes.
Unlawfully at large, indeed.
Indeed.
Because obviously a change in category somewhat changes the possibility of that occurring.
It does.
Are the lab team focusing on the risks that might arise in custody, at large, either or both?
Both, my Lord. They will still focus on that point when considering the question. As the lab team is, the purpose of the lab team, as it were, is to consider whether to make a recommendation to the director, whether that individual's security categorisation should be downgraded or otherwise. So that will be in their mind. And that's at 4.2 of the prison service instruction I previously mentioned, in an effort to assist my Lord's page 257 of the authorities bundle. In this case, the challenge is dealing with the necessity or otherwise of an oral hearing to review that detention. And therefore, paragraph 4.7 of the prison service instruction becomes relevant, my Lords, page 258. And to use the words of that PSI, we see there that it refers to factors that would tend in favour of an oral hearing being appropriate. And the prison service instruction refers at 4.7a onwards to 4 factors or areas that may become relevant. In this case, it is the first 2, my Lord, that we say were abundantly relevant, 4.7a and 4.7b. 4.7a refers to important facts in dispute. It goes on to provide a little more clarification there, where it reads, facts are likely to be important if they go directly to the issue of risk. Even if important, it will be necessary to consider whether the dispute would be appropriately resolved at a hearing. For example, where a significant explanation or mitigation is advanced, which depends upon the credibility of the prisoner, it may assist to have a hearing at which the prisoner and or others can give his or their version of events. Paragraph 4.7b, my Lords, refers to where there is a significant dispute on the expert material.
Well, could we, because these, as it were, straddle different grounds, we just pause in relation to A? What was what is your case in relation to what important facts were in dispute in this case?
2 points, my Lord, in the main. First, what, if anything, the appellant was required to do before a downgrade has been deemed to be suitable. And we see the LAP report and those contributing to the LAP, prison psychologist, etc., effectively saying he has achieved all he needs to achieve. And that leads them to recommend that he be downgraded.
That's not a fact.
Well, the appellant would submit that
No, it's a judgment made on the basis of facts. I mean, I could understand, for example, if a prisoner was knocked back because he had not done the ABC course, and he said he had. Well, clearly it might not take long to work out the answer to that, but nevertheless, that's a dispute of fact.
Yes.
In anybody's book. But in a case where the prisoner has done the ABC course, but one person says that's made a big difference and another person says it hasn't. That's not a fact.
My lord.
I mean, I'm illustrating it
Of course.
in a way that I know you follow.
Yes.
So at the moment, I haven't. You've given us one instance, which was what were the expectations.
Indeed.
And the second instance you were going to give was?
Second point relates to behaviour on one of the units in the category A estate. There is a dispute.
Which unit was that?
Apologies,
Which unit was that?
Apologies, my lord.
Pipe one or the? There's been a Westgate unit as well.
Yes, my lord. The pipe unit, PIPE, at HMP Franklin.
Yes. And the reference where's the reference to the issue?
The issue in that, my lord, is to assist in the bundle, I referenced that at paragraph 2.3, which was on the original statement of facts and grounds. That's perhaps the most ideal place to take the quote from.
And the page for that is?
Page is L130 in the core bundle.
Thank you.
What we say the dispute there is first the reasons why Mr. Murcott left the pipe unit.
I'm sorry, could you just give us that page again?
Yes, it's not that.
It's not quite right, I don't think.
Apologies, my lord.
Sorry, which paragraph
I think I may be working from an outdated bundle, actually.
Which paragraph was it?
It's paragraph 2.3.
Okay, so that's on
7.
page 138.
Apologies, my lord.
138, yes.
That's my bundle issue.
So what was the, looking at that quote at 2.3, what was the point of, what was the dispute of fact?
2.3 is the position of, is the information that's contained within the lab report.
Yes.
Defendant seemingly, I'm conscious of the point that your lordship raised in relation to the first point in relation to whether it is a dispute of fact or not, and I anticipate the position. But the defendant takes a different position as far as reasons for withdrawal, removal, and consequences.
Well, if for example, it said, for example, he was deselected due to an outburst of anger. I could see that if, in fact, he was deselected, I don't know, for not turning up or whatever it was, that might be a dispute of fact. But is it a dispute of that nature? Or is it...
My lord, with hindsight, I think I might have to concede that it is a judgment issue.
A judgment.
Rather than a fact issue.
All right, well, I'm sorry to have taken you out of your road, but just to understand what's involved in that point.
Can I just, sorry for my part, just understand what you said the dispute was in the first place? I appreciate it's to do with why he left, taken off pipe, but...
The dispute that I say it was, my lord, is impact of him being removed and leaving that unit, and whether there is anything further that he needs to do as a consequence. Because what we see from the psychologist's position in the lab report, and this perhaps possibly lends itself more to ground 2 rather than ground 1, is that the psychologist's position, to simplify and summarise, is effectively, well, he may not be on that unit anymore, but in any event, he achieved everything that he needs to and will do on that unit.
Yeah.
And effectively suggesting...
In other words, he made significant progress on the unit.
Indeed, and therefore the reasons why he has been removed are not necessarily of impact and import as far as that decision is concerned. But I take the point made, my lords, that perhaps lends itself further to ground 2 in terms
It's really
of
about the significance and consequences of his exiting from that particular programme.
So if I can just briefly, my lord, go back to the policy and rule framework, as that was dealing with 4.7a.
Yeah.
4.7b is where there is significant dispute on the expert materials. It goes on within 4.7b to say this: these will need to be considered with care in order to ascertain whether there is a real and live dispute on particular points of real importance to the decision. If so, a hearing might well be of assistance to deal with them. Examples of situations in which this factor will be squarely in play are where the lab, in combination with an independent psychologist, takes the view that downgrade is justified, or where a psychological assessment produced by the Ministry of Justice is disputed on tenable grounds. There is then reference to a parole board position which is not relevant in this case, but to conclude that paragraph, my lords, it reads, it is emphasised again that oral hearings are not all or nothing. It may be appropriate to have a short hearing targeted at the really significant points in issue. My lords, that is the relevant policy framework.
What's the, I appreciate we're looking here at some guidance,
Yes.
but take the example where the lab, in combination with a psychologist, takes the view that downgrade is justified.
Mm-hmm.
What's the dispute in that being the situation?
Yes.
What is the dispute that is intended by that guidance in your understanding?
Well, that effectively, my lord, leads to ground 2. And what the dispute that the appellant would say is that the lab, taking into account those that contribute to the lab, for instance, the prison psychologists, that for the purposes of the decision being taken, that information is expert information. So the defendant is also an expert in the categorisation of prisoners. That is,
yes. I'm wondering whether really this is intended to focus on a dispute, or whether it's really intending to say, if everybody says that there should be a recategorisation, but you don't think you agree, you, the director, don't think you agree, you should give them an oral hearing.
indeed.
Well, that's, but because they don't seem to fit together, the parts of that guidance, that it could be read in that way, could it?
Yes, it doesn't necessarily fit together quite nicely,
No.
but that is effectively, my lord, what we are saying as far as as far as ground 2 are concerned. That on a strict reading of dispute of expert materials in this context, we may view an example as being prison psychologist says no for whatever reason, independent psychologist says yes.
I mean, I could see that might have appeared as an example,
And that
but that's not the example.
that is not the example here, no.
No, it's not. It's not the example here. It's not even an example that is given there.
It is, my lord, I think it is deliberately wide. It can be interpreted widely in my submission, dependent upon the facts of the case.
Well, at the moment, it seems to me as a newcomer to this paragraph that it begs more questions than it answers. But that may assist you.
My lord,
can I just ask, who, again, slightly strange to this, who is the independent psychologist referred to in that? Do sometimes prisoners seek their own independent psychological?
yes, my lord, exactly that.
I see.
In this case, there isn't an independent psychologist, but on a number of occasions, a prisoner who has legal representation, that prisoner's solicitor may instruct an independent psychologist to undertake a risk assessment.
Well, one can see, for example, let's suppose you did have a flat-out dispute between the quote, prisoner's psychologist and members, at least some members of the lab. One could see that it would place maybe the director in some difficulty in reaching a decision themselves, without knowing necessarily where the balance fell between one and the other. But it reads quite oddly in a situation where you've got the lap as a whole being all of the advice,
Indeed.
saying one thing, but no apparent dispute in view.
No, my lord, and this is a point that was made at the lower courts and to a certain degree is made again here, that there is unanimous support before it gets to the director, unanimous support from everyone that everything that could be done has been done and risk is reduced.
Because you can't really say the lap says this, the director says no, therefore we've got to have a dispute. And therefore we've got a dispute, so we have to have a hearing, because that means the hearing would take place after the decision.
No, my lord, I don't quite put it like that. What I say in that circumstance, what ought to happen is that directors should be reviewing it where there is unanimous support. If the director is taking issue with something in that he does not agree upon, it is at that point that triggers.
So it's a minded to situation, is it? If having looked at it, the director is, I mean, obviously if the director says, I accept the advice, well then, fine.
Then he's downgraded.
Then that's fine. But if the director says, I'm minded not to accept it, that's the situation in which you're arguing this would speak in favour of there being.
That the director should have turned his, I mean that, and I accept the director does turn his mind to the question of oral hearing within the originally impugned decision. He considers it and says, we do not need one in this case.
On the face of it, it would therefore cover every situation where the director, where you've got everybody in the lap, for example, saying downgrade, and the director saying no, that he'd had to have an oral hearing, wouldn't he?
I don't seem to interpret it that
Well, you
way.
might not, but why not?
Because I also accept that every case does turn on its own facts, and it depends why the director.
I see. So it's not that he disagrees with the conclusion, it's something within supporting the inclusion.
It is not simply the disagreement that almost automatically gives rise to the oral hearing. I don't make that submission, and I also accept entirely that I can't make that decision, that submission. The authorities are very clear on that point, and it still remains the position that oral hearings for Category A prisoners will be rare. They will. But I also say that the defendant ought to still have in his mind as a primary consideration the consideration of procedural fairness to the individual who is making that application for downgrade.
So in this case, what do you say that the particular matter was, or matters, that required an oral hearing?
So in this case, my lord, I think perhaps if we refer initially to the case of Crown on the application of H, which I mentioned at the outset.
But what in this particular case, before going to the authorities?
The basis of the defendant's decision not to downgrade is primarily he recognises to a degree the progress that that the individual has made, Mr. Murcott has made, but is effectively saying he wants to see a further period of good behaviour, stability, etc. before considering.
Yeah.
So that's one expert view, as it were. The alternative, or the opposite expert view, or at least what the appellant says is the expert view, is that no, this isn't required. All of this work.
Sorry, no what?
No
further time required.
That further period is not required. That risk has reduced to an appropriate level. Because these questions that are being asked are all dependent, all surround this question of risk and what that level of risk is. And we see that in the test, the risk when or if unlawfully at large. So there is a risk assessment dispute between the director on the one hand and the LAP on the other. And I use LAP as a group phrase in this case because there are individuals that contribute to the LAP process and they all say the same thing. that nothing further needs to be done, can be downgraded, risk at an appropriate level. So what the director is doing is making a specific disagreement. There is also this issue of the impact or otherwise of the deselection and removal from the pipe unit at HMP Franklin, which again the director refers to as being not necessarily determinative, but it is an issue that is weighed and considered to lend itself to the director's position, whereas if we compare that to the position of the psychologist, and indeed the prison psychologist takes an entirely different position from the director. So we say that this is the dispute between experts that falls within 4.7b of the PSI.
So two things, basically.
Two things, my lord.
I just wondering, as you spoke, the dispute between experts, and I may have fostered that idea as well. A significant dispute on the expert materials is what it actually says.
Indeed, my lord. And, my lord, I would respectfully say that that doesn't change the position.
No, I'm wondering whether that helps you somewhat.
My lord. And if I can come back to the case of Crown on the application of H, which I referenced a moment ago, in particular paragraph 23 of H. Judgment to Mr. Justice Cranston, he finds as follows. On 2 occasions, the local prison has recommended that the claimant should be recategorised. As a consequence, there is an inconsistency between, on the one hand, the approach of the local prison and, on the other hand, that of the director of high security prisons. I do not accept the claimant's submission that this results in an impasse. This matter is also different from that considered in the Williams decision, since the recommendation of a local prison on categorisation is not the same as a decision of the parole board. That paragraph, my lords, also goes on to say this, and it's this element that the appellant would say is specifically relevant. Nonetheless, this inconsistency supports the case for an oral hearing to explore it in greater depth. At the end of the day, there may be no inconsistency, but simply a difference of opinion, and for very good reasons, but is as well that the matter be explored at an oral hearing. So the inconsistency in H was the decisions of the local prison, the LAP, when compared to the position of the director of high security. Now in H, there were 2 decisions, subsequent decisions, where...
I don't know the facts of H, but as Justice Cranston referred to an inconsistency of approach. Is that the same as simply saying that they approached the matter in the same way but reached different decisions? I mean, is there something elsewhere in H that shines light on what an inconsistency of approach is?
My lord, the inconsistency of approach is the fact that the LAP on 2 occasions, 2 annual occasions, have said, downgrade this gentleman.
I understand, but it seems rather strange use of terms. I mean, it's a disagreement about consequences, but normally an inconsistency of approach is that somebody was doing one exercise and somebody was approaching the exercise in a different way. I don't know whether there's anything you can say about that, but...
If I can just turn off.
Do you say it was simply the same situation as existed here?
Lord, effectively, yes, that is what the appellant is saying.
All right.
And as far as the argument is concerned. Now, the originally impugned decision in this case was the first decision, the first occasion that the appellant had been recommended for a downgrade, and that is the decision that was challenged before the lower courts. As the matter was progressing through the lower courts, as it happens on a number of occasions, an annual review had taken place, a subsequent decision had taken place. That subsequent decision was again, from the LAP, downgrade this gentleman from category A, and again, Director of High Security said no.
And the judge in our case knew this.
Which in this case knew that. So it is a slightly different case when we look at H, because H arguably was considering the second decision in time. This case considered, as far as judicial review, the first decision, but there is perhaps an analogy that can be drawn when we note that that second decision wasn't.
I think he dealt with this in the judgment, didn't he?
To a certain degree, my lord, yes, on the question of whether the claim itself was rendered academic by virtue of that second decision.
Yeah.
Submission made, and in fairness, it was an agreed position between myself and my learned friend that it wasn't. I think if memory serves me correctly, the case is crowned on the application of Clark. It's
Wilson.
It's Wilson.
So apologies, Wilson. Judgment of Mr. Justice Fordham. Yes. That considered a similar position on the Category A review and said that the question arising from the grant or otherwise of an oral hearing is not rendered academic by a subsequent decision. But yes, Upper Tribunal Judge Ward was aware of that.
The Court of Appeal in Clark has said that it's probably not very fruitful to look at first instance decisions because all of these cases turn very much on their own
Yes, ma'am.
facts. And that decision was given last year, I think.
My lord, yes.
I think it's it's a 2024 decision. So is there really any value in looking at to see what other judges in other first instance cases have done?
My lord.
Of course, if they've made a statement of principle, it might be relevant, but simply looking at what they've done in other cases probably doesn't help, does it?
My lord, my learned friend says, no, it doesn't help. I take a slightly different position in that my submission would be this. I don't seek to dispute Clark or say that Clark was decided wrongly, and that every decision in relation to these types of cases are judged on their own facts. So a first instance decision does not bind a further court on that similar issue. But where I differ, if I may, my lord, is what I say that, well, as much as it doesn't bind, at the same time, my submission would be that they can't be rejected as simply being irrelevant. That there are still issues and principles that have been considered previously by the court that may be analogous to a further case that is before the court that raises those similar principles. So I don't put the case as high as to say, well, for instance, if we use H as the example, that in H the decision was as it was, therefore this court is bound to follow that. I don't say that. I don't put my case that highly. But what I do say is, well, a similar position arose in H. I also will refer in a few moments to a case of Zaman, that where we see similar issues being considered by the court previously, we can derive some benefit from that.
That was one of the ones that Clark said it wasn't fruitful to look at.
Indeed.
So
the
the Court of Appeal has already said this in Clark. Is it really going to be of assistance to us to look at other first instance decisions?
My lord, where there are similar or the same or analogous facts, my lord, I would say yes, but I also take your lordship's point. I don't seek to push the issue any further than I have outlined.
Just before going, can I just clarify one thing, which I haven't picked up from the papers? The decision that is under review, as it were, and in this case, this was the first time that the appellant had been recommended by the LAP for downgrade to Category B.
I believe so.
Yeah. Thank you.
My lords, if I can briefly turn back to my skeleton argument, and looking specifically at paragraph 36, my lord, I'm remaining with ground 2. I think ground 1 has already been dealt with, although slightly a little out of order as far as fact or judgment is concerned. So remaining with ground 2, paragraph 36, the appellant in this case would maintain that where there is universal support for a downgrade from the lap and those contributing to the lap panel, yet the defendant rejects that position or all of those positions, as it were, this of itself can, not necessarily always will, but can, and in the instant case does constitute a relevant dispute for the purposes of subparagraph B of the PSI in terms of the expert material, expert evidence point.
I think you might be entitled to say that even if this situation doesn't fall fairly and squarely within B, that it's the sort of situation where you might expect coherent guidance to say that this would be one of the situations in which a prisoner was entitled to an oral hearing, or at least entitled to good consideration for an oral hearing.
Yes.
I mean, in other words, unwritten guidance.
My lord, yes. And I accept that to a certain degree the facts of this case do not neatly place themselves in the box that A and B seem to draw. They don't neatly fit in those. There is a degree of interpretation that I am making in my submissions, and indeed that I asked the lower court to make, that in terms of the facts of this case do fall within those two boxes, that fair and just consideration and that an oral hearing ought to have been granted.
Well, particularly in circumstances where you gain support from C and D.
My apologies, my lord.
Where you gain support from C and D.
My lord, C and D are relevant, but C and D are not necessarily determinative, and that there must be more there, as it were. I think I would be hard pressed to make an argument to any court that, for instance, simply because an individual had spent a long period of time in custody as a Category A prisoner, that of itself ought to give rise to an oral hearing. I don't think I could make that argument. But C and D are there, in my interpretation, as factors to be considered in the round, yeah. And it may be that they add weight, yeah, to A and B, which are perhaps the more predominant ones. My lords, I reference Armand at paragraph 38. My lord has already noted the point in respect to that and how it is considered in Clark. The element that I say that is important there is this issue. The reason I use that is this issue of independent psychologist, as that is noted as being where there is a dispute with the independent psychologist. The reason I raise that here is that there is no independent psychologist in this case, but in the appellant submission that ought not to take away from the weight of the recommendation of LAP, because although there is no independent psychologist, the prison psychologist, and therefore the defendant psychologist, is making the recommendation for downgrade in any event. So the fact that there are not two psychologists with opposing positions in my submission is not fatal to the application, as that would appear to put the appellant at a disadvantage simply because he has not instructed. And in my submission, my lord, that could not or ought not.
So in Clark, the dispute was between the LAP who were for staying in Cat A and the psychologist who was for downgrade.
Mm-hmm. So my lord, if I can try and draw those points together, as I've alluded to, we do not necessarily have in this case a clear and obvious specific point that falls neatly into the boxes drawn with A and B of the PSI. But when we consider all of those relevant factors in the round, the appellant says this is where upper tribunal judge will err in not considering that the position of LAP, its findings, its recommendations, when compared to the position of the defendant, when those other considerations are taken into account, C&D, time spent, no oral hearing before, etc. All of that in the round can be considered to be that relevant dispute. And that relevant dispute on expert materials that does fall into that box drawn by B. And therefore that is something that would lend itself to being better resolved by way of oral hearing.
The previous oral hearing really falls away, doesn't it, if this was the first time that downgrade had been recommended by LAP?
Well, my lord, I would say not necessarily with respect, as the grant of an oral hearing is not predicated on there being a recommendation from LAP. As much as I would accept entirely that without a recommendation from LAP, it may even be more surprising.
Be a brave director, isn't it? Yeah.
That an oral hearing be granted. But it is not necessarily impossible to envisage circumstances where there may be something in the LAP recommendation that the director sees that may fall to be better considered by way of oral hearing to ascertain the wider circumstances of it. As I say, my lord, it is perhaps even more rare than an ordinary oral hearing following recommendation, but not necessarily impossible. And therefore, my lord, I'd still submit that that position is relevant, although again, the issue is one of weight to be attached to it. So, my lords, that effectively deals with grounds 1 and 2, which concerns the substantive decision of the director, if I can.
Well, I think if it seems to me that if we were to say that your focus was very largely on ground 2,
My lord,
would that be a fair summary?
that would be correct, my lord. I certainly would not take issue with it. So moving to ground 3. Ground 3, my lord, arose, ancillary is the wrong word, but it's an issue that arose after the oral submissions were made, and therefore there is to a degree a separation between grounds 1 and 2 and grounds 3. So it arises out of what occurs post-hearing. Paragraphs 43 and 45 of my skeleton argument outlines the position there. So the question, if I can put it that way, to be considered is whether it was appropriate for Upper Tribunal Judge Ward to rely on a communication purporting to answer the question raised by the judge, whether it was appropriate to rely on a communication where that communication was not accompanied by any evidence confirming the same. For example, a statement by the Director of High Security confirming the position. And in circumstances, my lords, where the appellant would submit that obtaining that evidence was, or at least ought to have been, a relatively straightforward task. The appellant would submit, noting 46 of my skeleton, my lords, that the correct course of action in those circumstances would have been for Upper Tribunal Judge Ward to reject the respondent's position in the absence of that supporting evidence, e.g. a witness statement with a signed statement true, or require that that accompanying evidence be filed to confirm the position before making a determination.
Could you just walk us through what, I mean, happily you were both involved in this process, but you leave with the issue of the other reports having surfaced during the course of the argument.
No, my lord.
Not at all, or
Not at all.
Right.
And it was the judge who did it, wasn't it? It was a
Yeah.
It was up at Tribunal Judge Ward who spotted the issue of his own.
Well, I
ownership after.
appreciated that that the judge had not seen them. I had wrongly assumed clearly that there had been some passing reference to them.
No, my lord, this is an issue, if memory serves me correctly, and my learned friend will tell me if I'm wrong, this is an issue that arose post-conclusion of the hearing
but
entirely.
in a sense, the judge took a point that it was open to either party to have taken,
Yes,
but they didn't.
but we didn't.
Right. So it wasn't, in a sense, something that had been concealed from everybody. It was hiding in plain sight, as
Not
it
at
were.
all. Yes.
The judge then says, I think I ought to hear from you about these.
Yes,
And presumably sends a message to both of you
you did, my
with
lord.
that request. And what he says he did was invite post-hearing submissions.
You did?
And he got them.
Yes, my lord.
And what we're focusing here on is the answer that came from the Secretary of State through Mr. Cohen, which was actually the director did see these.
Yes, my lord.
And what was your post-hearing submission?
My post-hearing submission is...
No, what was it to the judge?
It was similar to the submission that I'm going to make now, is that simply accepting it, and I'm very careful in the use of my language because I'm not maligning my learned friend whatsoever,
Yeah.
but to simply accept it on the basis that Mr. Cohen had been advised by those instructing him that the director had was not enough.
Okay. Is there something in our papers where we can see this exchange between counsel and the court? So we, because I'm sure it was all in writing.
Yes, it was, my lord. The submissions ought to be there. They are. Supplementary bundle, grateful.
Thank you. Right,
Supplementary
post-hearing
bundle,
submissions.
Part E.
Right, so email from the judge at 75.
My lord.
Dated the 14th of April. And we then have a note on behalf of the Secretary of State,
It's at 77, my lord.
77, dated the 16th of April. And then your post-hearing submission, you can now take us to, also on the 16th of April, but was that in knowledge of the Secretary of State's
You were
document,
instantaneous.
or did they?
Yes. No, they were filed on the same occasion, my lord. They weren't subsequent filings.
Right, so they're not sequential.
No, they're not sequential.
Right,
my lord.
so we'll find something in here which you'll take us to in a moment, which says what you say about this. But we won't find anything that says what you say about Mr. Cohen.
No, my lord, that's correct.
Right, and having seen, I mean, I don't want to jump ahead, but having seen what Mr. Cohen said, you didn't then say, well, let's see that above a signature.
I didn't, my lord, no, because as I say, my lord, the submissions were filed at the same time,
Yes.
and there wasn't that direction, as it were, by a tribunal to file a second set.
No,
as
I
it were.
understand that, but just so that we can understand that the issue that arises under ground 3 is not an issue that crystallised before the judge, even post-hearing.
No, my lord.
Okay, right. Now, could you then, can either take the time to read what you were saying, or you could just take us to the bits that matter in your own submission?
The submission that was made to a tribunal judge
Yes.
Ward, my lord, yes. So I effectively posed 2 questions, or 2 points to consider. That's at 2.1a and b.
That's the judge's
Yes.
issues.
I then deal with those in turn. So the first one at 2.3 was the reasoning set out. I referenced the fact of Miss Mitchinson's evidence to the lab, where she says this report must be read in conjunction with my two previous reports, therefore referencing the fact that that was important to enable the director at that stage to have a full and accurate picture of the risk assessment, and Miss Mitchinson, who's a psychologist, prison psychologist, her reasoning as to why she was recommending that downgrade. So that's the position of why it was important. Paragraph 2.8 onwards, my lords, I deal with whether an oral hearing would have allowed that point to be considered further. My submission is that yes, it goes to this question of procedural fairness, and therefore if they are not before the director, or even if they were
So
before
the issue
director,
that we're concerned with now is a completely different issue.
yes,
Because you were making the argument, perfectly fairly as it seems to me, is that if the director didn't have those, then it wouldn't be fair.
my lord, yes.
The answer, unbeknown to you, was going to the court that the director did have those, and we're now concerned about whether that answer was presented in satisfactory form.
My lord, yes.
So it's a completely different
It
issue.
is different than the issue
what
that
was
was raised.
concerning you in.
Yes.
Okay.
Yes, it is an entirely different issue than the issue that was argued before the court as it were and raised.
Right, well, let's leave aside whether or not there ought to have been either on the initiative of the judge or on the initiative of yourselves, further exchange of views. What's the consequence of this for the appeal?
Consequence that Helen says, my lord, is that it has been accepted by Upper Tribunal Judge Ward that the director did have these two previous reports before him when he considered, and to rely effectively without a statement or evidence confirming that position, that is where the error arose. And that Upper Tribunal Judge Ward should have taken a step further and either rejected the position of the defendant, as I mentioned a moment ago, that that wasn't enough, or said, well, that's fine, but let me see some evidence that that did happen, i.e. a statement from the director accompanied by a statement of truth.
Well, I would have thought the more obvious way of approaching it would have been for him to have gone back to you and said, anything further you want to say about this?
My lord.
Because otherwise the court is entitled to rely upon public bodies' duty of candour. In a sense, here there was no objection was raised because there was no, as it were, an opportunity for an objection had not been specifically created.
The submissions were on consequence rather than form, if I can phrase it like that. My lord, the remainder of
But you're able to make those arguments in any event on the basis of the undertaking, as it were, that that's what had happened. This is simply one on the form of how it was provided to the judge,
my lord, yes.
by way of a response by counsel or indeed simply a sworn statement.
My lord, yes.
And
And
really what
it
it
is that
comes to.
narrow point.
Yeah.
And in making that point, I refer in my skeleton argument to the Police Superintendents Association, helpful summary of principles there, again by Mr. Justice Fordham. I raise principles 4, 5, 7 and 10 as being appropriate, and my lords, I'm looking at paragraph 15 of that judgment, which is page 204 of the bundle. My lords, in particular, principle 7, documents should be produced, not gisted, or a secondary account given. My lord, I say that's precisely what this is. It's a secondary.
This isn't a case where there was a document.
No.
This is just about the way that the evidence was given. It's not.
Indeed, my lord.
He's talking there about the case where there is some document, and instead of just handing over the document,
Yes.
a description is given of it, for example. And he says that's not good enough, but that's not this case.
My lord. Reference of principle 4. Mr. Justice Fordham refers to it as the information to principle and references Belize Alliance, dissenting judgment of Lord Walker, which is page 20 of your
And
authority.
I don't think there's anything in the JR guide about this situation.
I don't think there is one.
No, I mean, which is helpful communications between the court and counsel after the event, which, as it were, run out before the point that then comes up. But I think you very helpfully explained how this emerged for us to be able to consider it.
My Lord, I think the remainder of the submissions on that point are perhaps adequately dealt with in writing. I'm more than content to expand if your Lordships require me to do so, but I think your Lordships have the point that is being made that is there. My Lords, on that basis, I don't necessarily see...
There's one sort of overall point that I'd be interested to hear from you on, which is this, that originally and up to the actual hearing before the judge, you had two strings to your bow. One which was a plain irrationality challenge,
Yes.
and the other which sort of started out as a bit of a hybrid in the pleading, but was presented to the court, in fact, as a procedural unfairness challenge. And so what has survived to this point, as you were very clear that you were going on the second, not on the first?
The procedural fairness is the underlying
Yes.
point.
So is it, I mean, is the way in which you put it this, that in a world in which you are not entitled to an oral hearing, you don't pursue the argument that the decision was irrational?
Well, I can't...
Well, I realise you. I know that, but in a sense, I'm just formulating it. That if one was to put oneself into a position where you were not entitled to an oral hearing, then in those circumstances, you're not arguing before us that the decision was irrational.
No, my Lord.
Right. What I understand you to be doing, but this may not be correct, is to say that in a world in which you should have had an oral hearing, one cannot know whether the decision was rational or not.
I think I quite put it like that.
How would you put it?
And the reason, or at least the main reason, that the question of rationality or otherwise falls away comes back to the point in Wilson and the academic point. So the fact that there was a second decision that supersedes the first, that, in my submission before the lower courts, and again agreed position, that leads to the irrationality argument falling away because the decision...
Right. So in that case, let me get out of your way and you say, what do you say the consequence would be of your argument in relation to an oral hearing succeeding? Where does it take you?
Well, it takes us to a procedurally fair assessment that enables both appellant to put his case for downgrade, challenge the director's point, and also at the same time enables the director, where he doesn't agree with psychologist assessment, wing officer assessment, it enables that evidence to be challenged. It's not a situation that is akin to Osborne and Booth, for example, with the application for oral hearing before the parole board where detention is reviewed. It is not so stark, and the authorities underneath the PSI are clear. We are not in an Osborne and Booth situation, but the consequence of it is where we can perhaps draw an analogy there, my Lord, in answer to your question. It allows the whole process of review of an inmate's categorisation to be determined through a fair process.
Let's pursue the idea that we're very taken with one or other of your grounds. And we say, well, yes, really, we go back to 2024, really ought to have been an oral hearing. It was procedurally unfair that offer was not made. Where does that take us in 2026?
My apologies, my Lord.
No, it's a different point.
Appellant remains a Category A prisoner.
Yes, but
Now, so it still takes.
I'm really asking what good does it do you to succeed on this ground when you didn't proceed on the first one? How does it work?
If we succeed on this ground, then my submission would be that that would lead to a decision that the oral hearing should have been granted.
Right. An oral hearing should be granted, but would it lead to any relief in circumstances where things have moved on to such an extent?
Potentially, my lord, yes, because that oral hearing could still lead to a fresh decision where it may be that the appellant is downgraded to category B, which is what the purpose of the position back in 2024 would have been. It would have been the oral hearing to review detention, to review categorisation. So, in essence, we are in precisely the same position now, March 2026, as we were in 2000.
How do we know? I mean, I appreciate that there was one further review in 2025. Presumably there'll be a further review in 2025.
There has been a third, I am aware of. I don't have the details of the
No, exactly, but
I think
it may mean, depending upon the consequences of the 2026 review, it may be that this is either academic because there's going to be an oral hearing, or there's going to be an agreement to recategorisation, or that things have changed in such a way that an oral hearing would be a waste of time.
My lord, I take the point.
So, I mean, in a sense, are you in a sense asking for a judgment rather more than for a specific relief? Because if you're asking for specific relief from us, I think we need to know what it is.
My lord, yes. My lord, it's an entirely appropriate question. I don't necessarily think I can answer it. My learned friend might be able to help a little further. I can certainly ask those instructing me who do sit behind me, fortunately, that during perhaps my learned friend's submissions.
Well, I mean, if it's been helpful, I'm content to have floated the idea, at least before we end this hearing, if we could have a little bit more of a concluded view from the parties about that.
I can certainly ask for inquiries to be made as to what the position is in respect of the most recent review, the third review, if I can.
Well, I don't want to ask that any inquiries are made which are rushed, not systematic, etc., etc. I just would like to have a general view as to where matters stood, so that, for example, if your appeal was to succeed on some ground or other, then it might be necessary for the court to ask for submissions as to what the consequences were, and those submissions to be properly thought about.
Of course,
we don't want to, in that situation, arrive at the point that was reached below, when there was a sort of rather unsatisfactory exchange of.
Of course. My lord, perhaps if I can put it like this as a proposal, then, if I turn my back and when my learned friend makes his submissions in response, those instructing me can see with their office as to whether that third decision, if I can characterise it that way, has been made. If that third decision is in writing and they have a copy of that decision, we then have a definitive position that I may be able to assist the court with then.
Well, I'm not in any sense suggesting that if there was further information, we'd look at it. But
of course,
I just wanted to get a general view of the horizon at the moment.
My lord.
The second decision was made by the director, again without an oral hearing.
It was, my lord, yes.
Yeah. And to a certain extent, wasn't this was at least canvassed before the upper tribunal judge, wasn't it?
My lord, it was raised to the...
Because he deals with in paragraph 6.
It was, my lord. It was raised in terms of considering whether the claim before
was academic.
The judge was academic.
Yeah.
But it wasn't given consideration as such.
No, but he quotes from Justice Fordham and Wilson.
Yes.
And in that case, I'm not saying it's the same in this case, what should happen, to quote from it, is that an oral hearing at which all the relevant materials considers on an up-to-date basis. And that's presumably what you were contending for.
That is the relief.
And is that really what the relief that my lord was asking about?
Yes.
So that's your position?
Yes.
I see.
But I take the point my lord makes in respect of what that, if there is a third decision, what it says. So
it'd be surprising, well, no, it wouldn't be surprising, but you'd have thought you might have heard about it if there'd been an oral hearing.
I'm relatively certain.
And if he'd been downgraded as well.
For that reason, my lord, that there has been no oral hearing and there hasn't been downgraded, or else
you'd have heard about
well, I certainly would hope I would have been made aware.
Yeah.
But indeed, my lord, unless I can assist further.
I'm sorry to carry on the same theme as the point that's just been discussed. We're now 2 years on. Presumably, and again, this is something you can find out, but presumably your client has each time asked for an oral hearing.
Yes, Mother.
What the cases show is that the decision whether or not to grant an oral hearing is itself fact sensitive, depends on all the circumstances at the particular time. Presumably different material has been put before the decision maker in both 2025 and 2026. So I understand the point that's made in that quote from Wilson, but how does it work practically? Because the facts may be different.
My Lord, yes, the facts may be different. So the fresh review will take into account of developments in that 12-month period. Now, it may be that there are adverse developments, for instance. At the same time, it may be that there are no developments in terms of it may simply be the individual has spent another 12 months as a Category A prisoner. So the new report for the new review will provide an updated position, as it were. Now, I can't say what is in those reports because evidently I do not have them, and they're certainly not before the court. But it is not necessarily the case that the information that is provided is entirely fresh. So in this case, for example, we have an inmate who, on the face of it, has completed all offending behaviour work that he needed to at this juncture. So I would be surprised if a subsequent review was to say, well, he's all of a sudden completed this offending behaviour, because at that point it says that they have all been done, for instance. So it wouldn't be that fresh information. There would be updated reports in terms of his behaviour, whether there has been any instances of prison adjudications for offences against prison discipline, for example, whether there has been any change in behaviour and risk profile for any psychologist to comment upon. So yes, to answer the question, my Lord, the information would be new, and I appreciate this next point is perhaps unhelpful, but the extent to which it is new, if that makes sense, depends on that intervening 12-month period, yes, and whether anything of note has actually occurred. Now in this case, Director is saying we want to see 12-month settled behaviour, and the LAP panel says that there's no offending behaviour.
But I mean, the more I think about this, I mean, you know, heaven forfend there'd be a dispute of fact about what had been going on in the meantime, but even if there wasn't, the mere passage of time would suggest that the most that could realistically be achieved on this appeal would be an order that the decision be retaken.
My Lord.
It seems to me impossible for us to direct that there should be an oral hearing without having anything more than the vaguest understanding of what was actually happening in real life.
Certainly, my Lord, and given the passage of time, and certainly at least one, potentially two reviews since, I certainly...
And even so, that sort of even a direction of that sort would seem to add very little to a judgment which, in the situation we're talking about, is favourable to you.
Indeed, my Lord.
So it's all hypothetical, but a favourable judgment might in a sense be the real gain.
And my Lord, yes, I think if that was the case, if there was a favourable judgment, and again, I'm certainly not second guessing your lordships, no, but a favourable judgment would potentially, in my opinion, add weight to any subsequent.
You appreciate, as I've said more than once, that this is, in a sense, we're just covering all the ground to make sure that we don't have to have post-hearing correspondence.
No, of course. My Lord.
Is there anything else?
Thank you.
No. Well, thank you very much indeed, Mr. Buckley. Yes, Mr. Cohn.
My Lords, in my submission, the core principles relevant to the issues in this appeal are firstly the decision in Clark and the recognition by the Court of Appeal that, in my submission at least, the question for the judge was an evaluative assessment of the fairness of the procedure that had been followed. And I'll return to Clark in due course, but it's paragraph 111 that I particularly rely upon. And secondly, the second core principle, the issue for the director was not, in my submission, a hard-edged question of fact-finding. Rather, the director was required to undertake a more free-flowing, evaluative judgment as to risk, specifically the risk that the appellant would have posed if unlawfully at large. And that is, of course, different to the types of factual judgment that might otherwise require an oral hearing to be held. And in my submission, Hassett reflects on those principles. So, my Lords, for my submission, the paramount question that the upper tribunal judge had to consider was as to the fairness of the proceedings before the director and the decision of the director as a whole, bearing in mind that his task, the director's task, was not primarily to find facts. My Lords, my submission is that the learned judge properly understood and considered that issue. And I particularly rely upon paragraphs 44 and 57 of the judgment of the court below. At 44, the upper tribunal judge observed that he agreed with my analysis of the director's decision, which addressed the correct test, took into account points on both sides of the equation, reached a conclusion that was entirely rational given all the matters that were taken into account, and showed that it had done so. And then at paragraph 56, the final paragraph, the learned judge explains that the claimant had had input into the process and broadly concludes that he didn't consider in the round that there had been any breach of the obligation to have a fair procedure. So in my respectful submission, upper tribunal judge Ward properly directed himself as to the legal parameters that he had to apply and made no error in his overarching conclusion. My Lords, in respect to the learned friend's first ground, by which it is said that this was a dispute of fact case, it's worth turning, reflecting first on the observation and the holding in Clark, which is that one is not to apply the criteria in the prison service instruction mechanistically. These are factors that might tend to support the holding of an oral hearing. They are not a checklist whereby, if a condition is fulfilled, an oral hearing is mandatory. And my Lords, without taking you to the judgment in Clark, it explains that the approach taken in the PSI is to place mandatory instructions in italicised font, and that other aspects of the PSI which are not in italics are expressly not said to be mandatory, that the section containing the provisions where an oral hearing might tend to be appropriate are not in italics, and that in consequence they are indicative and not mandatory. So that's the first point to make about the PSI, but the next point about the PSI, which is page 258 in B258 in the authorities bundle, paragraph 4.7 A is that the PSI itself expressly observes that a factor that would tend to favour an oral hearing is where important facts are in dispute. Facts are likely to be important if they go directly to the issue of risk. So in other words, the PSI does not say that wherever there is a factual dispute, an oral hearing must follow. The PSI says that an oral hearing might, my emphasis, be appropriate where important facts are in dispute, and then clarifies that a fact is important if it goes directly to the issue of risk. And my lords, to take a counterfactual example, my submission is that paragraph is most usually engaged in circumstances, for instance, where there has been a violent incident between a prisoner and either a member of staff or another prisoner, and there is a he said dispute as to exactly what the violent incident involved or entailed, what the motivations of the people were, etc. And the director is having to make a conclusion on risk, returning to my core principle, based on an evaluation of what propensity that incident may indicate a prisoner has, and where the prisoner says, but hang on, you don't understand, I didn't throw the first punch, it was somebody else. That is the sort of situation where an important factual dispute would exist, which an oral hearing could sensibly cut through and allow the director to reach a safer and, in my respectful submission, more fair conclusion. To the contrary, my submission is that the upper tribunal judge here properly concluded that there were no such important factual disputes. I don't labour the point because my learned friend didn't place huge emphasis on this ground of appeal, but in my respectful submission, my Lord Justice Peter Jackson is correct that the first alleged factual dispute is actually an issue of judgment, not a dispute of fact. And the second matter, which concerns the circumstances in which the appellant left a particular unit, was not an especially significant aspect of the director's decision. If one looks at page M155 in the core bundle, one can see reasons for the decision at the top of the page. The second paragraph after that heading.
Sorry, which page you want?
M155.
Thank you.
The second larger paragraph after the underlying text, beginning with the words the director recognises. About halfway down that paragraph are the words, since that time, Mr. Murcott has been deselected from both the Westgate unit and the Pipe unit, the latter in 2023. The director noted that Mr. Murcott has since last year achieved a period of stability and improved self-management. So the circumstances in which Mr. Murcott had exited whichever unit, but were not at the centre or indeed the front of the director's reasoning. It was at best a peripheral aspect of the factual matrix. So even if it was correct to suggest that a factual dispute existed on that issue, my submission, my lords, is that it would not have been a matter that required an oral hearing. And in consequence, the learned judge made no error in concluding that this was not a dispute where the overarching requirements of fairness needed an oral hearing to explore that dispute. My lords, turning to the second ground concerning the suggested dispute between experts, once again, my lords, I rely on those core principles and the observations in Clark that the purpose or that the exercise that is required is not a mechanistic reading of the policy to assess whether a particular criteria is or is not met in a very legalistic sense. Rather, a more broad brush question of fairness arises. My submission is that the effect of ground 2 which would be to require an oral hearing in circumstances where there is a dispute between the director in his conclusion or his likely conclusion and the other or the experts, would substantially increase the number of oral hearings required. Albeit I agree with my learned friend that would tend to fly in the face of the decision of Lord Justice Sales, as he then was, in Hassett. In my submission, there is no support for the approach that the appellant now takes in the authorities. Standing back, the question and the issue for the director is about risk, and that is an issue on which the director alone must make a decision, of course informed by the submissions made on behalf of the prisoner and by the professional judgments of other participants in the process. But ultimately, it is for the director to reach that decision. And it is not, in my respectful submission, clear that whenever the director finds himself unable to agree with the opinions of others, that he should have to hold an oral hearing for that apparent disagreement to be thrashed out. Lords, I accept that it might be the case if there was an equivocal expert conclusion, or if an expert in a very complicated case gave an observation that there were uncertainties about a particular prisoner's presentation, or if there were two experts, an independent expert instructed on behalf of the prisoner and a prison service psychologist who disagreed. These are the types of case where the PSI envisages an oral hearing to allow the contrasting opinions to be discussed and to be ventilated, particularly if issues of, for instance, diagnosis or something really fundamental to the issue of risk arose. But what fairness does not require, in my respectful submission, is for a hearing to take place simply because different people reach different conclusions, bearing in mind that the director is entitled to reach his own conclusion. My lords, the crucial point in my submission is reflected in the judgment of Upper Tribunal Judge Ward, where he makes the observation that the experts in this case had set out their opinions in writing in detail, had provided a very clear basis for the opinions that they expressed, and as such, this was not the type of case where there was a particular uncertainty or unexplored dispute where fairness might require a hearing, so that the director could, for instance, say, well, you've raised this point in your report, but I take a very different view, and in particular, I think you have missed the following points. That would be the type of case in which one could envisage the need for an oral hearing. If, in essence, the director was saying, well, I think your opinion is based on a series of false premises, or I am of the opinion that I don't understand your opinion. My judgment, my conclusion is I don't understand the opinions you've expressed. But here...
What's the overall question? Is it seen applying an objective standard, but from the perspective of the director, I cannot decide this matter fairly without an oral hearing. Seen from the objective standpoint of the director, they cannot decide this fairly without an oral hearing.
The question, my lord, is objectively, what would an oral hearing have added to the director's process?
And that must be a sub part of a broader of a broader endeavour, mustn't it be? I mean, what the prisoner is entitled to is fair consideration of their situation in relation to categorisation.
Well, yes.
So is the essential question, in the particular circumstances of the case, is an oral hearing required in order that a fair decision should be reached? And looking at it then at another remove, because it's the director that decides whether to grant an oral hearing or not.
Well, yes.
Objectively speaking, am I able to reach a fair decision in relation to this matter only after hearing submissions at an oral hearing, or can I reach a fair decision based upon what I've got?
Well, I think it's the first. In other words, the question is whether the director has objectively sufficient information to reach a fair decision.
Or are there features of the situation, some of which are more or less convincingly described in the guidance?
Lord, yes.
Which point me towards finding that I can't fairly decide this.
My Lord, yes. And are there fact-specific issues in a given case which mean that fairness requires the step of an oral hearing? And that is why I absolutely stand by the analysis in Clark, that the multitude of first instance decisions on this issue add very little, because each is so fact-specific that the question of whether fairness on those facts required an oral hearing or not doesn't add a great deal to the principles that actually arise. And my submission...
Can it really be just... It's not just limited to the director's point of view, isn't it, for the court to decide?
Lord, yes.
On the circumstances of the particular case, because obviously some of the criteria include, for example, the fact there hasn't been an oral hearing before, and or the length of time that the person's been in custody and so forth. Those aren't really matters that in themselves would particularly impact on a necessity for an oral hearing from the director's point of view. That was really from the appellant's point of view in this case.
Lord, that's correct. I had interpreted the inclusion of the word objectively in my Lord Justice Jackson's question to imply that the court was going to undertake that.
No, I wasn't talking about the court. I mean, the important person here for the workings of the system is the director, and that the director should, as often as possible, make good decisions in accordance with proper principles. And I mean, there might very well be, as the guidance says, a situation in which, in a marginal case, where somebody hadn't had the opportunity to, as it were, argue their case in live, where that might tip it, but it's no more than that. But in general, there's got to be some overriding principle as to, we're all for fairness, but what does fair, what makes a hearing in one case fair and another case unfair? It's presumably whether you conscientiously apply yourself to the right amount of information.
Oh, yeah.
So the key question, as it seems to me at the moment, is whether you've got the right amount of information already, or whether you can see for this or that reason that actually you need more information in order to be able to make a fair decision.
Well, yes, I respectfully agree with that, and it is important to note that we can all sometimes risk looking at this process through the paradigm of a court and assuming it's that sort of process. I'm not suggesting that this court...
No, the whole endeavour is to try and keep these things out of court.
Indeed, but the point I'm making is that because of the... It isn't the case that it comes to a point where the director has a hearing and makes the final decision. There are lots of opportunities for the prisoner to have input into the process long before it comes before the director. So, in a formal sense, as happened in this case, solicitors acting on behalf of the appellant put in submissions before the director in advance. But there's also a process by which the different report writers sit with the prisoner, the appellant in this case, and seek their view and put points to them, and that all gets incorporated within the bundle that then goes to the director. So although certainly I can be guilty of viewing this process very much almost as if it's an example of litigation and thinking that it all comes to a final point, the end of the funnel, but actually that's not the right paradigm. The correct view is
the end of the line is the decision. I mean, if there's going to be litigation about it, that's a completely different game.
My Lord, entirely. The point I'm just trying to make is that it's not understanding the fairness of the decision doesn't rely only on the final act in the drama. There is a whole process leading up to the review, which
And
incorporates.
so the question, as I come back to it again, which I'm asking you about, and may or may not be right, is that when that normal process has taken its course, has that produced enough information for the director conscientiously acting to be able to make a fair decision, or is something more required?
Lord, I respectfully agree, and in my submission, the learned judge made no error in concluding that because of all the information that was before the director, and because of all of the process, there was enough information for the director to make a fair decision without requiring an oral hearing. And in my submission, the matters in the PSI that tend to indicate a hearing might be required were not so engaged in this instance as the learned judge found.
Do you have anything to say about B, which we spent an inordinate amount of time looking at earlier on page 258 of the authorities?
Well, my lord, only to repeat the Clark point that what isn't required is
Well, I know, but we can't always run to Clark and say, well, it's just a matter of fact. I mean, these are serious decisions, and there are guidance. There is guidance for the assistants. I mean, B seems to me, as I've said, as a newcomer to it, to have a number of internal issues, including the fact that, for example, it doesn't particularly cover what we've got here. One would have thought that guidance would say, you know, where everybody thinks that there should be a recategorisation and the director doesn't, is one of the situations in which a director might decide to hold a hearing, you'd have thought.
Oh, yeah.
But it doesn't seem to be covered by that
No.
at all. Anyhow, if there's, as it were, a coherent reading of B that you wanted to help us with, I'd be glad to hear it. But if not, then
Well, I
it's
don't think I can add anything.
I wondered whether there was anything in, I mean, I'd be interested in your submission. I wondered whether there was anything in the Hazard case, as at page 135 of the bundle, that might throw some light on this. This is a case which is the case which was then reaffirmed, as it were, relied on by this court in Clark. And in that case at 67 and 68, Lord Justice Sales looks at a case where there is, he's looked at the rule that Lord Justice B. Jackson just referred to earlier in the judgment, and then he says what he says about a case where in that case there wasn't a significant difference of view amongst the experts. And he also makes the point that he had had a fair opportunity to explain himself to both psychologists and could not realistically be expected to provide further assistance on the question being addressed.
Lord, yes, and then at 69, often be unnecessary for the director to hold a hearing, even if there's a significant difference of view between the experts.
What he doesn't do in that passage, I should say, is actually analyse the wording of the rule, although he has referred to it earlier in the decision.
My Lord, indeed. I can't help the court to construe the rule with special clarity, other than to emphasise that these are merely factors tending to. It's not a mandatory instruction. And I think that the rule, that the PSI is drafted with an intent to be illustrative in a fairly broad brush sense, as opposed to providing a prescriptive set of circumstances. And thus any infelicities in its drafting may reflect a desire to avoid being too prescriptive, but I can't add anything.
Well, this was Hassett was a challenge to actually to be as not reflecting Osborne.
Lord, yes.
Yeah,
But I certainly do rely upon the principle that that Hassett lends significant support to the strength of the reasoning of Upper Tribunal Judge Ward in this case, and provides an answer to some of the criticism offered by the appellant. My Lord, turning to ground 3, I certainly accept with a degree of wincing.
Before you do that, I read somewhere that, I think it was in the guidance itself, that said that following Hassett it was expected there'd be more oral hearings.
Yes.
I'm struggling to find out where that comes from in Hassett, but I maybe don't.
Well, I don't know precisely. As a matter of fact, it has, I think, been correct.
It has?
There have been significantly more hearings latterly, and despite the observations in Hassett that these hearings will be rare, the plethora of first instance decisions on this issue show that it has in fact been a fertile area of litigation.
Yes, sorry, you were going to ground 3.
Lord, yes, I certainly have to begin by accepting with a degree of wincing on my part that it would have been a lot better if a witness statement had been prepared, and I regret that it wasn't. You didn't. You had no permission. No, well,
to file one. I mean, we perfectly follow what took place, but it seems as if it was an issue which arose and went nowhere at the time until you then received the judgment, and then it's sprung up as a grand consequence.
Funnily enough, that's the next observation I was going to make, which is that, in fairness, though, the judge didn't ask for a witness statement. He specifically asked, as you'll see in the supplementary bundle, for written submissions.
But you're not. I mean, you're not entitled to just file statements.
No.
I mean, you might have said, "These are my instructions. Do you want a statement?"
Oh, yes. It is also not unfamiliar in the administrative court for matters to arise and acting on behalf of a public body to receive instructions underscored by the duty of candour and to make submissions on the hoof, as it were, as to what the situation is. And that is in effect what happened here, albeit it happened after the hearing. The crucial points in my submission are really as follows. First of all, whatever else the import of ground 3 is, it doesn't affect the fairness of the director's decision. It's a matter really as to the process that was followed in the High Court, and therefore it's incapable of showing that the director got it wrong. The other point, however, is that the judge at paragraph 55 of his judgment fairly reflects on the matter and makes the fair and correct points that it was a point that hadn't been raised by the parties. The claimant didn't therefore actually have permission to raise it, albeit the judge of course raised it of his own volition. That it hadn't been raised in any of the proceedings before the director, and that in the circumstances he took the view that he would have given it limited weight on the overarching question of whether fairness meant that an oral hearing needed to be held. So in my submission, whatever else can be said about the manner in which the judge received the Secretary of State's position on that issue, it didn't have an overarching adverse effect on the nature of his conclusions as a whole.
We'd have to look narrowly, don't we, whether the way the judge treated the situation, which in fact arose, was a fundamental procedural error on his part. In the sense that if what appears at paragraph 55 is a way in which he was entitled to deal with the situation that had arisen, well, that's it. If he wasn't entitled to deal with it in that way, then a different consequence.
Well, yes. And in my submission, in essence, even if the approach taken was not optimal, it was not so procedurally problematic or unfair as to render his entire decision wrong. And
The conclusion, if he was, let's suppose we were outraged by what had happened and thought that Ground 3 was going to succeed and more, it would have to be reconsidered as a matter of public law as to what should happen next, namely, provide a statement, reconsider the whole thing.
Well,
And
yes.
it doesn't get back to the director.
no, I respectfully
It was
agree.
your first point.
I respectfully agree. And in my submission, this reflected very much the nature of judicial review procedure in which issues can arise and assurances can be made or submissions can be made on instructions, as I say, backed by the duty of candour, which don't therefore give rise to significant unfairness. My Lord, on the more general question, my Lords, on the more general question of relief, my submission is, first of all, at risk of making submissions afresh, I'm told that the most recent decision in respect of Mr. Murcott was made on the 20th of October 2025, and that he remains in Category A, and that he hasn't had an oral hearing. I've been sent the decision, but I haven't had time to read it.
So that's obviously post the hearing before the judge. So there have been two subsequent decisions have been made since the one that was originally under challenge.
Yes, I
Both
think
of them,
yes.
as it happens,
Yes.
in 2025.
Yes. In those circumstances, I would suggest that the only relief that this court could practically give would in effect be declaratory, because seeking to remit or to order an oral hearing to be held in circumstances where so much water has flown under so many bridges would be a fairly meaningless exercise.
Well, either a mandatory order to hold an oral hearing, or indeed a mandatory order to reconsider, because what you'd be reconsidering has long since
Being superseded.
gone under the bridge.
Lord, yeah, exactly, my Lord.
Right, so it would basically be a judgment which says we think this ought to have happened.
Lord, yes, we think this ought to have happened, which would then give significant support to the appellant in any future process in which he could say, well,
If the situation was otherwise...
exactly. My Lords, unless I can give any further assistance.
I take it the on the brief regard you've had to it, that the third decision, as it were, the most recent one, was made on the basis the LAP was still recommending downgrade, and the director decided otherwise.
No, actually, Lord, on a very brief review, the LAP on this occasion didn't recommend downgrade.
I see, maintaining Category A.
Lord, all I've looked at is its emboldened recommendation says that the LAP didn't recommend it, but I haven't had time to get into why that was.
No,
So I wouldn't want to.
Sure.
Looking at the decision, the director seems to have said, and of course I'll provide it to my own friend, that the director appears to have said that a number of report writers continued to support downgrade, the LAP did not, and therefore, well, and he remained in Category A. Lords, unless I can do
Anything else? Good. Thank you very much, Mr. Cohen. Mr. Buckley.
My Lord, just on one very brief point, and I don't necessarily think anything turns on it, but I feel it important to raise that, my Lord, in my submission, my learned friend puts his case too highly in respect of the consequences and issues arising out of Ground 3. So what my learned friend says in his submissions is that the issue concerning Ground 3 has no real impact on the procedural fairness of the proceedings being challenged. My Lord, I don't think it can quite go that far. If we look at the factual outline of that, the director, by the prison psychologist in their report, has been specifically and directly referred to two previous reports. Now, if the director has considered those reports, no issue. If the director has not considered those reports, despite being specifically and directly referred to them and, want of a better phrase, told to read them by that psychologist, if the director then doesn't, then in my submission, my lord, that directly does go to procedural fairness, because the director has explicitly not considered relevant information. As I say, my lord, I don't necessarily think anything turns on that point in this case, but I do feel it appropriate to just put that position.
But in a sense, you are, as you pointed out, it's not only separate, but these grounds are operating at two levels. That grounds 1 and 2 are operating at the fundamental level of the procedural fairness of the original decision. Ground 3 is operating at a separate level, which is to do with the treatment of the matter by the administrative court.
Indeed, my lord, that's correct.
By acting upon say-so,
Yes.
wherever it came from, rather than upon evidence.
Yes, my lord. Right. And just finally, my lord, an ML Learner Friend submission in respect of the October decision, the third decision. I'm grateful for his offer to provide it with me. Those instructing me have emailed that decision to me, so I am aware of it. My learned friend is correct. That was rejected, no oral hearing. There was support for a downgrade from report writers. LAP did not support as a general position. I've scanned the reasons why and formed my opinion of why, but I'm loath to put that before the court because it is a scan.
Well,
So,
it obviously run through
but
one's
that is
mind
the
to
factual
say
position.
that this is an important matter which the parties ought to have an opportunity to think about and provide short written submissions. But I'm very much of the mind, unless my lords take a different view, that this is not such a situation. That you've helped, this was a horizon issue for us rather than something that needed to engage with directly, and it's been helpful to know where matters stand. It has obviously no bearing on the merits of the issues that we've been considering, except possibly in relation to relief.
I'm grateful, my lord.
All right. Anything else?
Nothing further.
No. Well, thank you, Mr. Buckley. Thank you, Mr. Cohen. Thank you to those who support you. Really helpful to have the arguments so crisply identified and argued. We'll consider the issues and let you have our judgments in due course in draft. Please strictly observe the embargo at the head of the draft judgments, and in compliance with the instructions, let us have your help with any editorial corrections and a draft order. We'll then see that the judgments are promulgated in the usual way on the National Archive and Bailey, and make the order. Of course, if there are any issues on the order, you'll get short written submissions. We won't need to trouble you to come back at any stage in the process. Thank you very much indeed.
All rise, able.